If you suggest a doubt as to the morality of these institutions, it is boldly said that you are a dangerous innovator, a utopian, a theorist, a subversive. You would shatter the foundation upon which society rests. If you lecture upon morality or upon political science, there will be found official organizations petitioning the government in this vein of thought. That science no longer be taught exclusively from the point of view of free trade, of liberty, of property, and of justice, as has been the case until now, but also in the future science is to be especially taught from the viewpoint of the facts and laws that regulate French industry, facts and laws which are contrary to liberty, to property, and to justice. That, in government-endowed teaching positions, the professor rigorously refrain from endangering in the slightest degree the respect due to the laws now in force. Thus, if there exists a law which sanctions slavery or monopoly, oppression or robbery in any form whatever, it must not ever be mentioned. For how can it be mentioned without damaging the respect which it inspires? Still further, morality and political economy must be taught from the point of view of this law, from the supposition that it must be a just law, merely because it is a law. Another effect of this tragic perversion of the law is that it gives an exaggerated importance to political passions and conflicts, and to politics in general. I could prove this assertion in 1,000 ways, but by way of illustration I shall limit myself to a subject that has lately occupied the minds of everyone: universal suffrage. The followers of Rousseau's school of thought, who consider themselves far advanced, but whom I consider 20 centuries behind the times, will not agree with me on this, but universal suffrage, using the word in its strictest sense, is not one of those sacred dogmas which it is a crime to examine or doubt. In fact, serious objections may be made to universal suffrage. In the first place, the word universal conceals a gross fallacy. For example, there are 36 million people in France. Thus, to make the right of suffrage universal, there should be 36 million voters. But the most extended system permits only 9 million people to vote. 3 persons out of 4 are excluded, and more than this, they are excluded by the 4th. This 4th person advances the principle of incapacity as his reason for excluding the others. Universal suffrage means, then, universal suffrage for those who are capable. But there remains this question of fact. Who is capable? Are minors, females, insane persons, and persons who have committed certain major crimes the only ones to be determined incapable? A closer examination of the subject shows us the motive which causes the right of suffrage to be based upon the supposition of incapacity. The motive is that the elector or voter does not exercise this right for himself alone, but for everybody. The most extended elective system and the most restricted elective system are alike in this respect. They differ only in respect to what constitutes incapacity. It is not a difference of principle, but merely a difference of degree. If, as the Republicans of our present-day Greek and Roman schools of thought pretend, the right of suffrage arrives with one's birth, it would be an injustice for adults to prevent women and children from voting. Why are they prevented? Because they are presumed to be incapable. And why is incapacity a motive for exclusion? Because it is not the voter alone who suffers the consequences of his vote. Because each vote touches and affects everyone in the entire community. Because the people in the community have a right to demand some safeguards concerning the acts upon which their welfare and existence depend. I know what might be said in answer to this, what the objections might be, but this is not the place to exhaust a controversy of this nature. I merely wish to observe here that this controversy over universal suffrage, as well as most other political questions, which agitates, excites, and overthrows nations, would lose nearly all of its importance if the law had always been what it ought to be. In fact, if law were restricted to protecting all persons, all liberties, and all properties, if law were nothing more than the organized combination of the individual's right to self-defense, if law were the obstacle, the check, the punisher of all oppression and plunder, is it likely that we citizens would then argue much about the extent of the franchise? Under these circumstances, is it likely that the extent of the right to vote would endanger that supreme good, the public peace? Is it likely that the excluded classes would refuse to peaceably await the coming of their right to vote? Is it likely that those who had the right to vote would jealously defend their privilege? If the law were confined to its proper functions, everyone's interest in the law would be the same. Is it not clear that, under these circumstances, those who voted could not inconvenience those who did not vote? But on the other hand, imagine that this fatal principle has been introduced under the pretense of organization, regulation, protection, or encouragement. The law takes property from one person and gives it to another. The law takes the wealth of all and gives it to a few, whether farmers, manufacturers, ship owners, artists, or comedians. Under these circumstances, then certainly every class will aspire to grasp the law, and logically so. The excluded classes will furiously demand their right to vote, and will overthrow society rather than not to obtain it. Even beggars and vagabonds will then prove to you that they also have an incontestable title to vote. They will say to you, we cannot buy wine, tobacco, or salt without paying the tax, and a part of the tax that we pay is given by law, in privileges and subsidies, to men who are richer than we are. Others use the law to raise the prices of bread, meat, iron, or cloth. Thus, since everyone else uses the law for his own profit, we also would like to use the law for our own profit. We demand from the law the right to relief, which is the poor man's plunder. To obtain this right, we also should be voters and legislators in order that we may organize beggary on a grand scale for our own class, as you have organized protection on a grand scale for your class. Now, don't tell us beggars that you will act for us, and then toss us, as Mr. Mimerel proposes, 600,000 francs to keep us quiet, like throwing us a bone to gnaw. We have other claims, and anyway, we wish to bargain for ourselves, as other classes have bargained for themselves. And what can you say to answer that argument? As long as it is admitted that the law may be diverted from its true purpose, that it may violate property instead of protecting it, then everyone will want to participate in making the law, either to protect himself against plunder or to use it for plunder. Political questions will always be prejudicial, dominant, and all-absorbing. There will be fighting at the door of the legislative palace, and the struggle within will be no less furious. To know this, it is hardly necessary to examine what transpires in the French and English legislatures. Merely to understand the issue is to know the answer. Is there any need to offer proof that this odious perversion of the law is a perpetual source of hatred and discord? That it tends to destroy society itself? If such proof is needed, look at the United States. There is no country in the world where the law is kept more within its proper domain, the protection of every person's liberty and property. As a consequence of this, there appears to be no country in the world where the social order rests on a firmer foundation. But even in the United States there are two issues, and only two, that have always endangered the public peace. What are these two issues? They are slavery and tariffs. These are the only two issues where, contrary to the general spirit of the Republic of the United States, law has assumed the character of a plunderer. Slavery is a violation by law of liberty. The protective tariff is a violation by law of property. It is a most remarkable fact that this double legal crime, a sorrowful inheritance from the Old World, should be the only issue which can and perhaps will lead to the ruin of the Union. It is indeed impossible to imagine at the very heart of a society a more astounding fact than this. The law has come to be an instrument of injustice. And if this fact brings terrible consequences to the United States, where the proper purpose of the law has been perverted only in the instances of slavery and tariffs, what must be the consequences in Europe, where the perversion of the law is a principle, a system? Monsieur de Montalembert, politician and writer, adopting the thought contained in a famous proclamation by Monsieur Collier, has said, "We must make war against socialism." According to the definition of socialism advanced by Monsieur Charles Dupin, he meant, we must make war against plunder. But of what plunder was he speaking? For there are two kinds of plunder, legal and illegal. I do not think that illegal plunder, such as theft or swindling, which the penal code defines, anticipates, and punishes, can be called socialism. It is not this kind of plunder that systematically threatens the foundations of society. Anyway, the war against this kind of plunder has not waited for the command of these gentlemen. The war against illegal plunder has been fought since the beginning of the world. Long before the Revolution of February 1848, Long before the appearance even of socialism itself, France has provided police, judges, gendarmes, prisons, dungeons, and scaffolds for the purpose of fighting illegal plunder. The law itself conducts this war, and it is my wish and opinion that the law should always maintain this attitude toward plunder. But it does not always do this. Sometimes the law defends plunder and participates in it. Thus the beneficiaries are spared the shame, danger, and scruple which their acts would otherwise involve. Sometimes the law places the whole apparatus of the judges, police, prisons, and gendarmes at the service of the plunderers, and treats the victim, when he defends himself, as a criminal. In short, there is a legal plunder, and it is of this, no doubt, that Mr. de Montalembert speaks. This legal plunder may be only an isolated stain upon the legislative measures of the people. If so, it is best to wipe it out with a minimum of speeches and denunciations, and in spite of the uproar of the vested interests.